Welcome to Legal Listening, where audio Obiter is our thing. We're Carly and Zach, and we're so glad you're here with us today. So today on the podcast, we have a recent decision of Uber Technologies and Heller. This is a very in the news, de rigueur case. It involves an Uber driver, Mr. David Heller, and his contract that he had as a driver for Uber Eats with Uber, who is primarily, legally, they're seated in the Netherlands. So the decision is very long and very complicated, and it deals with, arbitration clauses and forum selection and a lot of specific details like that. And it's a split decision as well. So we have the majority, and then Justice Cote has a very, very strong dissent opinion, which very much disagrees with the majority's sort of new test they create almost about unconscionability. I hadn't seen the word unconscionability since 1L contracts. I don't think I had looked at it once since, because it's honestly just never come up, because I don't do a lot of business corporate-y type things, and I would find that's probably where it comes up the most, and I just hadn't seen it. And then I read this decision, and it was just, the left-wing lady in me just loved it. Loved the majority decision. Obviously, Justice Cote's decision, while I don't agree with it, it was very well written. I personally don't agree, but I can definitely see where she's coming from, and I totally understand the argument. But it was neat to sort of see, with something very relevant that most of us use, a very old doctrine like unconscionability sort of get reworked in real time.
Yeah, that's interesting, because I'm the same way. I don't hide, but contracts was my worst mark in 1L. And it's mostly probably because I didn't read enough of the cases. And so words like unconscionability gave me the old scare whenever I saw them. But when this case came out, I saw it trending on Twitter, and I was like, you know what, let's take a look, because this is a big deal, right? Because I've been in Ubers before, and I've had friends who've driven for Uber or, one of those cost sharing or ride sharing programs. So when I read it and I saw the word unconscionability come up through the dialogue, I was like, this is amazing. This is such a cool, way to review this type of contract law that I hadn't even considered. And the cool thing, I think, is how applicable across so many different areas of law you can apply this case, or likely it will be applied.
Oh, yeah, definitely. Especially because, the way the majority frames it sort of changes how we will likely use unconscionability, and it sort of opens it up to different avenues. Because, the way we were taught unconscionability is it sort of had to be egregious, right? It had to be an old lady who had dementia and a big bad bank comes along and takes advantage of her. It had to be, very unconscionable. And this is sort of saying, we have to pay attention to things like market forces and market power and all these other sort of factors. And it just really expands on the doctrine. It makes it much more interesting. And unfortunately, because me, I'm a big labor person. That's sort of my jelly. They didn't really talk about any of the arguments about the actual Employment Standards Act. Almost none of that made the final decision. It's just all three of the decisions focused almost exclusively on unconscionability and public policy concern and, arbitration clauses and international arbitration conventions. And a lot of the ESA stuff just, wholesale was not there in the final decision. I know all those people, the labor ministries and stuff, they all made submissions, but none of it sort of made the final decision. They declined to talk about it, which I think leaves the door open for more litigation, especially about the whole independent contractors and employees debacle that's going on in, tons of industries.
Oh, definitely. And it's with the rise of novel industries like Uber, Skip the Dishes, DoorDash, Airbnb, all these new, like I said, novel industries, it really opens the door for future litigation on employment law in particular, and likely as well tied to that labor law, which I learned there was a difference in 2L, that labor and employment they're not in fact the same thing when you would normally think they are.
They're not in fact the same thing, yeah. Well, yeah, especially even if you consider what just happened with Foodora, how Foodora, obtained union certification and then Foodora just pulled out of Canada. So it's, these issues are live issues. And I think it's only going to sort of continue to be so as the gig economy just keeps exploding, right? Like, what's a pension? Who knows? Like, it's, as long as work keeps being precarious, I think this stuff's going to keep happening.
Yeah, and even more so, I'm curious as to the litigation that's going to come out post-COVID-19. Once we get through, however long this takes to get through, I think, especially with gig economy workers, this is going to be interesting.
Oh, yeah. Well, we'll see you on the other side of that, and also enjoy the episode. Uber Technologies, Inc. and Heller. Heard before the Supreme Court of Canada on November 6th, 2019 and June 26th, 2020. On appeal from the Court of Appeal for Ontario. The judgment of Chief Justice Wagner and Justices Abella, Moldaver, Karakatsanis, Rowe, Martin, and Casarir was delivered by Justices Abella and Rowe. In this appeal, the court determines who has authority to decide whether an Uber driver is or is not an employee within the meaning of Ontario's Employment Standards Act, the Court of Ontario, or an arbitrator in the Netherlands, as provided for in the contracts of adhesion between Uber and its drivers. David Heller provides food delivery services in Toronto using Uber's software applications. To become a driver for Uber, Mr. Heller had to accept, without negotiation, the terms of Uber's Standard Form Services Agreement. Under the terms of the agreement, Mr. Heller was required to resolve any dispute with Uber through mediation and arbitration in the Netherlands. The mediation and arbitration process requires upfront administrative and filing fees of $14,500 USD, plus legal fees and other costs of participation. Mr. Heller earns between $400 and $600 Canadian a week. The fees represent most of his annual income. Mr. Heller started a class proceeding against Uber in 2017 for violations of the ESA. Uber brought a motion to stay the class proceeding in favor of arbitration in the Netherlands. In response, Mr. Heller took the position that the arbitration clause in Uber's services agreement is invalid, both because it is unconscionable and because it contracts out of the mandatory provisions of the ESA. The motion judge held that he did not have the authority to decide whether the arbitration agreement was valid and stayed Mr. Heller's proceeding. The Court of Appeal reversed this order, determining, among other things, that the arbitration agreement was unconscionable, based on the inequality of bargaining power between the parties and the improvident costs of arbitration. We agree with the Court of Appeal. This is an arbitration agreement that makes it impossible for one party to arbitrate. It is a classic case of unconscionability. Background. Uber operates a global business in more than 600 cities and 77 countries, with a customer base of millions of people and businesses. The company has been operating in Ontario for 8 years. Uber's software applications are widely used to arrange personal transportation, the rider and driver apps, and food delivery, the Uber Eats app. Customers and drivers can download Uber's apps onto their smartphones. Customers use the apps to place requests for transportation or food delivery. Drivers use the apps to view and respond to customer requests. Payment between the customers and drivers is facilitated through Uber apps, and Uber takes a share of the driver's payments. The first time drivers log on to an Uber app, they are presented with a Standard Form Services Agreement of around 14 pages. To accept the agreement, the driver must click I agree twice. Once the driver does so, the Uber app is activated and the services agreement is uploaded to a driver portal accessible to the driver through an online account. The parties to the services agreement are the driver and the Uber subsidiaries incorporated in the Netherlands with offices in Amsterdam. The services agreement includes mandatory arbitration and choice of law clauses, which state, quote, governing law, arbitration. Except as otherwise set forth in this agreement shall be exclusively governed and construed in accordance with the laws of the Netherlands, excluding its rules on conflict of laws. Any dispute, conflict, or controversy, howsoever arising out of or broadly in connection with or relating to this agreement, including those relating to its validity, its construction, or its enforceability, shall be first mandatorily submitted to mediation proceedings under the International Chamber of Commerce Mediation Rules, the ICC Mediation Rules. If such dispute has not been settled within 60 days after a request for mediation has been submitted under such ICC mediation rules, such dispute can be referred to and shall be exclusively and finally resolved by arbitration under the rules of arbitration of the International Chamber of Commerce, ICC arbitration rules. The dispute shall be resolved by one arbitrator appointed in accordance with ICC rules. The place of arbitration shall be Amsterdam, the Netherlands. The choice of law clause requires the agreement to be governed and construed in accordance with the laws of the Netherlands, excluding its rules on conflict of laws. The arbitration clause requires all disputes to be submitted first to mandatory mediation and, if that fails, then to arbitration, both according to the International Chamber of Commerce's rules. The place of the arbitration is to be Amsterdam. The upfront cost to begin an arbitration at the ICC, according to the ICC rules, amounts to about $14,500 US. The fees do not include legal fees, lost wages, and other costs of participation. The services agreement provides no information about the cost of mediation and arbitration. Mr. Heller is an Ontario resident who entered into contracts with corporations that are part of the Uber enterprise to be a driver. He earns approximately $400 to $600 Canadian per week based on 40 to 50 hours of work, or $20,800 to $31,200 per year before taxes and expenses. The cost to arbitrate a claim against Uber equal all or most of the gross annual income he would earn working full-time as an Uber driver. Mr. Heller started this proposed class action against Uber in 2017. He seeks relief for 4 claims in this proceeding: a claim for breach of the ESA, a claim for breach of contract based on either implied terms or the duty of good faith, a claim for negligence, and a claim for unjust enrichment. All of these claims, however, depend on the ESA for their success. The essence of Mr. Heller's position is that he is an employee within the meaning of the ESA. Uber, relying on the arbitration clause in its services agreement with Mr. Heller, sought a stay of proceedings in favor of arbitration in the Netherlands. Mr. Heller argued that the arbitration clause was invalid on 2 grounds. It was unconscionable, and it contracted out of mandatory ESA protections. The motion judge stayed the proceeding in favor of arbitration in the Netherlands. He began his analysis by determining which arbitration legislation applied: the Arbitration Act 1991, Statutes of Ontario, or the International Commercial Arbitration Act 2017, Statute of Ontario. The ICAA applies to arbitration agreements that are international and commercial. The motion judge proceeded on the basis that the ICAA applied because Mr. Heller and contracting Uber companies were based in different jurisdictions, and because there was, in the motion judge's view, a prima facie case that the agreement was a commercial licensing agreement. He then determined that the arbitration agreement's validity had to be referred to arbitration in the Netherlands in accordance with the principle that arbitrators are competent to determine their own jurisdiction, the competence principle. In the alternative, the motion judge held that the arbitration clause was not invalid due to unconscionability or because it contracted out of the ESA. He accordingly stayed the proceeding in favor of arbitration in the Netherlands. The Court of Appeal allowed Mr. Heller's appeal, finding that the arbitration clause was void both because it was unconscionable and because it contracted out of the ESA. Writing for a unanimous court, Appeal Justice Nordheimer concluded that Mr. Heller's objections to the arbitration agreement did not need to be referred to an arbitrator in the Netherlands and could be dealt with by a court in Ontario. He declined to resolve whether the AA or the ICAA applied, holding that the result would be the same under either statute. He found the arbitration clause to be unconscionable because it was an unfair bargain and resulted from significant inequality of bargaining power between Mr. Heller and Uber. He further noted that there was minimal chance of Mr. Heller having received legal advice, and that it was safe to infer that Uber knowingly and intentionally chose this arbitration clause in order to favor itself and thus take advantage of its drivers, who are clearly vulnerable to the market strength of Uber. The court also found the arbitration clause void because it contracted out of the ESA. As a result, the Court of Appeal allowed Mr. Heller's appeal and set aside the order of the motion judge granting Uber's motion to stay. Analysis. Throughout these proceedings, the parties have disagreed on the arbitration statute applicable to their dispute. Uber argued that the ICAA applies, and Mr. Heller argued that the applicable legislation is the AA. We agree with Mr. Heller. The parties' dispute is fundamentally about labor and employment. The ICAA was not meant to apply to such cases. The ICAA and the AA are exclusive. If the ICAA governs this agreement, the AA does not, and vice versa. As the Superior Court correctly identified, whether the ICAA governs depends on whether the arbitration agreement is international and commercial. That the agreement here is international is not in dispute. Whether the agreement is commercial is contested. To answer this question, one must understand the legislative scheme of the ICAA. The ICAA implements two international instruments: the Convention on the Recognition and Enforcement of Foreign Arbitral Awards, adopted by the United Nations Conference on International Commercial Arbitration in New York on June 10, 1958, and the UNCITRAL Model Law on International Commercial Arbitration, adopted by the United Nations Commission on International Trade Law on June 21, 1985, as amended by the United Nations Commission on International Trade Law on July 7, 2006. Only the model law is relevant here. Section 5.3 of the ICAA states that the model law applies to, quote, international commercial arbitration agreements and awards made in international commercial arbitrations, end quote. The meaning of commercial in this section of the ICAA must be the same as the meaning of commercial under the model law, as the latter states that it applies to international commercial arbitration. While the model law does not define the term commercial, a footnote to Article 1.1 provides some guidance. Quote, the term commercial should be given a wide interpretation so as to cover matters arising from all relationships of a commercial nature, whether contractual or not. Relationships of a commercial nature include, but are not limited to, the following transactions: any trade transaction for the supply or exchange of goods or services, distribution agreement, commercial representation or agency, factoring, leasing, construction of works, consulting engineering, licensing, investment, financing, banking, insurance, exploitation agreement or concession, joint venture, and other forms of industrial or business cooperation, carriage of goods or passengers by air, sea, rail, or road, end quote. The analytical commentary on draft texts of a model law on the international commercial arbitration, reports of the Secretary General, further explains that labor or employment disputes are not governed by the term commercial, despite their relation to business. 2 points emerge from this commentary. First, a court must determine whether the ICAA applies by examining the nature of the parties' dispute, not by making findings about their relationship. A court can more readily decide whether the ICAA applies, or an arbitrator can more readily decide whether the model law applies, by analyzing pleadings than by making findings of fact as to the nature of the relationship. Characterizing a dispute requires the decision maker to examine only the pleadings. Characterizing a relationship requires the decision maker to consider a variety of circumstances in order to make findings of fact. If an intensive fact-finding inquiry were needed to decide if the ICAA or the model law applies, it would slow the wheels of an arbitration, if not grind them to a halt. The second point to draw is that an employment dispute is not covered by the word commercial. The question of whether someone is an employee is the most fundamental of employment disputes. It follows that if an employment dispute is excluded from the application of the model law, then a dispute over whether Mr. Heller is an employee is similarly excluded. This is not the type of dispute that the model law is intended to govern, and thus it is not the type of dispute that the ICAA is intended to govern. This result is consistent with what courts have held. It is also consistent with the model law's reference to trade transactions, which, as Gary B. Bourne observes, quote, arguably connotes involvement by traders or merchants as distinguished from consumers or employees, end quote. Further, one could draw a negative inference from the definition's omission of employment relations. It seems unlikely to us that the drafters of the model law would have included such a thorough list of included commercial relationships and not considered whether to include employment. Employment disputes, in sum, are not covered by the ICAA. The AA, therefore, governs. The AA directs courts, on motion of a party, to stay judicial proceedings when there is an applicable arbitration agreement in Section 7. But a court has discretion to retain jurisdiction and decide to stay proceedings in 5 circumstances enumerated in Section 7(2). 1. A party entered into the arbitration agreement while under legal incapacity. 2. The arbitration agreement is invalid. 3. The subject matter of the dispute is not capable of being the subject of arbitration under Ontario law. 4. The motion was brought with undue delay. Or 5. The matter is a proper one for default or summary judgment. The only relevant exception here is paragraph 2 of Section 7(2), which gives the court discretion to refuse to grant a stay if the court determines that the arbitration agreement is invalid. The AA is silent on what principles courts should consider in exercising their discretion to determine the validity of an arbitration agreement under Section 7(2). But some criteria were set out in Dell Computer Corporation and Union des Commerçants and Seidel and Telus Communications Incorporated, which interpreted similar arbitration regimes in Quebec and British Columbia. In those decisions, this court set out a framework for when a court should decide if an arbitrator has jurisdiction, instead of referring that question to the arbitrator out of respect for the competence principle. Under the Dell framework, the degree to which courts are permitted to analyze the evidentiary record depends on the nature of the jurisdictional challenge. When pure questions of law are in dispute, the court is free to resolve the issue of jurisdiction. Where the questions of fact alone are in dispute, the court must normally refer the case to arbitration. Where questions of mixed fact and law are in dispute, the court must refer the case to arbitration unless the relevant factual questions require, quote, only superficial consideration of the documentary evidence in the record, end quote. In setting out this framework, Dell adopted an approach to the exercise of discretion that was designed to be faithful to what the international arbitration literature calls the prima facie analysis test as regards question of fact and questions of mixed fact and law. Under this test, the court must, quote, refer the parties to arbitration unless the arbitration agreement is manifestly tainted by a defect rendering it invalid or inapplicable, end quote. To be so manifestly tainted, the invalidity must be incontestable, such that no serious debate can arise about the validity. Rather than adopting these standards literally, Dell gave practical effect to what was set out in the arbitration literature by creating a test whereby a court refers all challenges of an arbitrator's jurisdiction to the arbitrator unless they raise pure questions of law or questions of mixed fact and law that require only superficial consideration of the evidence in the record. The doctrine established in Dell is neatly summarized in its companion case, Rogers Wireless and Murhoff. Quote, the majority of the court held that, when an arbitration clause exists, any challenges to the jurisdiction of the arbitrator must first be referred to the arbitrator. Courts should derogate from this general rule and decide the question first only when the challenge to the arbitrator's jurisdiction concerns a question of law alone. Where a question concerning jurisdiction of an arbitrator requires the admission and examination of factual proof, normally courts must refer such questions to arbitration. For questions of mixed fact and law, courts must also favor referral to arbitration, and the only exception occurs when answering questions of fact entails a superficial examination of the documentary proof in the record, and where the court is convinced that the challenge is not a delaying tactic or will not prejudice the recourse to arbitration." End quote. The parties agree that the framework from Dell and Seidel applies to Ontario's Arbitration Act. We agree based on the similarities between the arbitration regimes in Ontario, British Columbia, and Quebec. The two exceptions to arbitral referral in Dell and Seidel therefore apply in Ontario. This case, according to Mr. Heller, engages one of those exceptions because it requires at most only a superficial review of the record. Neither Dell nor Seidel fully defined what is meant by a superficial review. The essential question, in our view, is whether the necessary legal conclusions can be drawn from facts that are either evident on the face of the record or undisputed by the parties. Although it is possible to resolve the validity of Uber's arbitration agreement through a superficial review of the record, we are of the view that this case also raises an issue of accessibility that was not raised on the facts in Dell and justifies departing from the general rule of arbitral referral. As Dell itself acknowledged, the rule of systematic referral of challenges to jurisdiction requiring a review of factual evidence applies normally. This is not one of those times. The underlying assumption made in Dell is that if the court does not decide an issue, then the arbitrator will. As Dell said, the matter, quote, must be resolved first by the arbitrator, end quote. Dell did not contemplate a scenario wherein the matter would never be resolved if the stay were granted. This raises obvious practical problems of access to justice that the Ontario legislature could not have intended when giving courts the power to refuse a stay. One way, among others, in which the validity of an arbitration agreement may not be determined is when an arbitration is fundamentally too costly or otherwise inaccessible. This could occur because the fees to begin arbitration are significant relative to the plaintiff's claim, or because the plaintiff cannot reasonably reach the physical location of the arbitration. Another example might be a foreign choice of law clause that circumvents mandatory local policy, such as a clause that would prevent an arbitrator from giving effect to the protections in Ontario employment law. In such situations, staying the action in favor of arbitration would be tantamount to denying relief for the claim. The arbitration agreement would, in effect, be insulated from meaningful challenge. These situations were not contemplated in Dell. The core of Dell depends on the assumption that if a court does not decide an issue, the arbitrator will. Against these real risks of staying in action in favor of an invalid arbitration, one could pit the risk of a plaintiff seeking to obstruct an arbitration by advancing spurious arguments against the validity of the arbitration. This concern animated Dell. In our view, there are ways to mitigate this concern that make the overall calculus favor departing from the general rule of referring the matter to the arbitrator in these situations. Courts have many ways of preventing the misuse of court processes for improper ends. Proceedings that appear vexatious can be handled by requiring security for costs and by suitable awards of costs. In England, courts have awarded full indemnity costs where a party improperly ignored arbitral jurisdiction. Further, if the party who successfully enforced an arbitration agreement were to bring an action, depending on the circumstances, they might be able to recover damages for breach of contract, that contract being the agreement to arbitrate. Moreover, Dell itself makes clear that courts may refer a challenge to arbitral jurisdiction to the arbitrator if it is, quote, a delaying tactic, end quote, or would unduly impair the conduct of the arbitration proceeding. This provides an additional safeguard against validity challenges that are not bona fide. How is a court to determine whether there is a bona fide challenge to arbitral jurisdiction that only a court can resolve? First, the court must determine whether, assuming the facts pleaded to be true, there is a genuine challenge to arbitral jurisdiction. Second, the court must determine from the supporting evidence whether there is a real prospect that, if the stay is granted, the challenge may never be resolved by the arbitrator. While this second question requires some limited assessment of evidence, this assessment must not devolve into a mini-trial. The only question at this stage is whether there is a real prospect in the circumstances that the arbitrator may never decide the merits of the jurisdictional challenge. Generally, a single affidavit will suffice. both counsel and judges are responsible for ensuring the hearing remains narrowly focused. In considering any attempt to expand the record, judges must remain alert to the, quote, danger that a party will obstruct the process by manipulating procedural rules, end quote, and the possibility of delaying tactics. As a result, therefore, a court should not refer a bona fide challenge to an arbitrator's jurisdiction to the arbitrator if there is a real prospect that doing so would result in the challenge never being resolved. In these circumstances, a court may resolve whether the arbitrator has jurisdiction over the dispute, and in doing so, may thoroughly analyze the issues and record. Turning to the appeal before us, we would first observe that Mr. Heller has made a genuine challenge to the validity of the arbitration agreement. The clause is said to be void because it imposes prohibitive fees for initiating arbitration, and these fees are embedded by reference in the fine print of a contract of adhesion. Second, there is a real prospect that if a stay is granted and the question of the validity of the Uber arbitration agreement is left to arbitration, then Mr. Heller's genuine challenge may never be resolved. The fees impose a brick wall between Mr. Heller and the resolution of any of the claims he has leveled against Uber. An arbitrator cannot decide the merits of Mr. Heller's contention without those, possibly unconscionable fees first being paid. Ultimately, this would mean that the question of whether Mr. Heller is an employee may never be decided. The way to cut this Gordian knot is for the court to decide the question of unconscionability. We would therefore resolve the arguments Mr. Heller has raised against the validity of Uber's arbitration agreement rather than refer those arguments to arbitration in the Netherlands. We observe, incidentally, that departing from the general rule of arbitral referral in these circumstances has beneficial consequences. It will prevent contractual drafters from evading the result of this case through a choice of law clause. A choice of law clause could convert a jurisdictional question that would be one of law, and therefore could be decided by a court, into a question as to the content of foreign law, which would require hearing evidence in order to make findings as to the content of foreign law, something that one would not ordinarily contemplate in a superficial review of the record. This is a significant loophole for contractual drafters to exploit. Indeed, Uber's contract here includes a foreign choice of law clause. As the intervener, Canadian Federation of Independent Businesses, submitted, this court should presume that Dutch law governs the question of whether the arbitration agreement is unconscionable because the contracts have a choice of law clause indicating Dutch law. Neither party, however, chose to lead evidence of Dutch unconscionability law. Since the parties chose not to lead evidence of Dutch law, this court must address the issue of unconscionability according to Ontario law. If Uber had adduced evidence of Dutch law, then under the two exceptions to arbitral referral recognized in Dell, this court would have had to grant the stay in favor of an arbitrator determining the unconscionability argument. As well, even though this case could have been resolved based on undisputed facts, such an approach may not be sustainable in future cases. An approach to arbitral referral that depends on undisputed facts would invite parties to dispute facts. Were that standard to apply, unreasonably disputing facts would allow a party to evade any review of the merits by use of an arbitration clause. There would be no negative consequence in this context to a party unreasonably disputing facts if it meant the stay in favor of arbitration would be granted. This differs significantly from the standard civil litigation context, wherein unreasonable disputes as to facts can be deterred by cost awards. We turn finally to the validity of the arbitration agreement. As mentioned, Mr. Heller raised two independent arguments as to why the arbitration agreement with Uber is invalid. First, the clause is void for unconscionability, and second, the clause is void because it contracts out of the ESA. We agree with Mr. Heller that the arbitration agreement is unconscionable. The parties and interveners focus their submissions on unconscionability in accordance with this court's direction in TELUS Communications Incorporated and Wellman, that, quote, arguments over any potential unfairness resulting from the enforcement of arbitration clauses contained in standard form contracts are better dealt with directly through the doctrine of unconscionability, end quote. Unconscionability is an equitable doctrine that is used to set aside, quote, unfair agreements that resulted from an inequality of bargaining power, end quote. Initially applied to protect young heirs and the poor and ignorant from one-sided agreements, unconscionability evolved to cover any contract with the combination of inequality of bargaining power and improvidence. This development has been described as, quote, one of the signal accomplishments of modern contract law, representing a renaissance in the doctrinal treatment of contractual fairness, end quote. Unconscionability is widely accepted in Canadian contract law, but some questions remain about the content of the doctrine, and it has been applied inconsistently by lower courts. These questions require examining underlying contractual theory. The classic paradigm underlying freedom of contract is the freely negotiated bargain or exchange between autonomous and self-interested parties. At the heart of this theory is the belief that contracting parties are best placed to judge and protect their interest in the bargaining process. It also presumes equality between the contracting parties, and that the contract is negotiated, freely agreed, and therefore fair. In cases where these assumptions align with reality, the arguments for enforcing contracts carry their greatest weight. But these arguments, quote, may speak more or less forcefully depending on the context, end quote. As Professor Atier has noted, quote, the proposition that a person is always the best judge of his own interests is a good starting point for laws and institutional arrangements. But as an infallible, empirical proposition, it is an outrage to human experience. The parallel moral argument that to prevent a person, even in his own interests, from binding himself is to show disrespect for his moral autonomy can ring very hollow when used to defend a grossly unfair contract secured at the expense of a person with little understanding or bargaining skill, end quote. Courts have never been required to take the ideal assumptions of contract theory as infallible empirical propositions. Equitable doctrines have long allowed judges to, quote, respond to the individual requirements of particular circumstances, humanizing and contextualizing the law's otherwise antiseptic nature, end quote. Courts, as a result, do not ignore serious flaws in the contracting process that challenge the traditional paradigms of the common law of contract, such as faith in the capacity of the contracting parties to protect their own interests. The elderly person with cognitive impairments who sells assets for a fraction of their value, the ship captain stranded at sea who pays an extraordinate price for rescue, the vulnerable couple who signs an improvident mortgage with no understanding of its terms or financial implications. These and similar scenarios bear little resemblance to the operative assumptions on which the classic contract model is constructed. In these kinds of circumstances, where the traditional assumptions underlying contract enforcement lose their justificatory authority, the doctrine of unconscionability provides relief from improvident contracts. When unfair bargaining cannot be linked to fair bargaining, when they cannot be attributed to one party's donative intent or assumed risk, as Professor Benson put it, courts can avoid the inequitable effects of enforcement without endangering the core values on which freedom of contract is based. This explains how unconscionability lines up with the traditional accounts of contract theory while recognizing the doctrine's historical roots in equity, which has long operated as a corrective to the harshness of the common law. This court has often described the purpose of unconscionability as the protection of vulnerable persons in transactions with others. We agree. Unconscionability, in our view, is meant to protect those who are vulnerable in the contracting process from loss or improvidence to that party in the bargain that was made. Although other doctrines can provide relief from specific types of oppressive contractual terms, unconscionability allows courts to fill in gaps between the existing islands of intervention so that the clause that is not quite a penalty clause or not quite an exemption clause or just outside the provisions of a statutory power to relieve will fall under the general power, and anomalous distinctions will disappear. Openly recognizing a doctrine of unconscionability also promotes fairness and transparency in contract law. There is value in recognizing that, quote, judges are and always will be concerned with unfairness, with arrangements that work harshly, and with conduct that is oppressive, end quote. The unconscionability doctrine allows courts to, quote, focus expressly on the real grounds for refusing to give force to a contractual term said to have been agreed to by the parties, end quote. As Chief Justice Dixon observed in Hunter, quote, in my view, there is much to be gained by addressing directly the protection of the weak from overreaching by the strong. There is little value in cloaking the inquiry behind a construct that takes on its own idiosyncratic traits, sometimes at odds with concerns of fairness, end quote. Most scholars appear to agree that the Canadian doctrine of unconscionability has two elements: an inequality of bargaining power stemming from some weakness or vulnerability affecting the claimant, and an improvident transaction. This court has long endorsed this duality. In Hunter, Justice Wilson observed that, quote, the availability of a plea of unconscionability in circumstances where the contractual term is per se unreasonable and the unreasonableness stems from an inequality of bargaining power was confirmed in Canada over a century ago, end quote. In Norberg, Justice Laforet described proving the elements of unconscionability as, quote, a two-step process involving 1, proof of inequality in the positions of the parties, and 2, proof of an improvident bargain, end quote. The concurring judgment in Duez and Facebook Incorporated followed a similar approach in a case involving a standard form consumer contract. We see no reason to depart from the approach to unconscionability endorsed in Hunter, Norberg, and Duez. The approach requires both an inequality of bargaining power and a resulting improvident bargain. An inequality of bargaining power exists when one party cannot adequately protect their interests in the contracting process. There are no rigid limitations on the types of inequality that fit this description. Differences in wealth, knowledge, or experience may be relevant, but inequality encompasses more than just those attributes. These disadvantages need not be so serious as to negate the capacity to enter a technically valid contract. In many cases where inequality of bargaining power has been demonstrated, the relevant disadvantage impaired a party's ability to freely enter or negotiate a contract, compromised a party's ability to understand or appreciate the meaning and significance of the contract terms, or both. One common example of inequality of bargaining power comes in the necessity cases, where the weaker party is so dependent on the stronger that serious consequences would flow from not agreeing to a contract. This imbalance can impair the weaker party's ability to contract freely and autonomously, when the weaker party would accept almost any terms, because the consequences of failing to agree are so dire. Equity intervenes to prevent a contracting party from gaining too great an advantage from the weaker party's unfortunate situation. As the Privy Council has said, quote, as a matter of common fairness, it is not right that the strong should be allowed to push the weak to the wall, end quote. The classic example of a necessity case is a rescue at sea situation. The circumstances under which such agreements are made indicate the weaker party did not freely enter into the contract, as it was the product of his extreme need to relieve the straits in which he finds himself. Other situations of dependence also fit this mold, including those where a party is vulnerable due to financial desperation or where there is a special relationship in which trust and confidence has been reposed in the other party. Unequal bargaining power can be established in these scenarios even if duress and undue influence have not been demonstrated. The second common example of an inequality of bargaining power is where, as a practical matter, only one party can understand and appreciate the full import of the contractual terms, creating a type of cognitive asymmetry. This may occur because of personal vulnerability or because of disadvantages specific to the contracting process, such as the presence of dense or difficult to understand terms in the parties' agreement. In these cases, the law's assumption about self-interested bargaining loses much of its force. Unequal bargaining power can be established in these scenarios even if the legal requirements of contract formation have otherwise been met. These examples of inequality of bargaining power are intended to assist in organizing and understanding prior cases of unconscionability. They provide two examples of how weaker parties may be vulnerable to exploitation in the contracting process.
Regardless of the type of impairment involved, what matters is the presence of a bargaining context, quote, where the law's normal assumptions about free bargaining either no longer hold substantially true or are incapable of being fairly appreciated, end quote. In these circumstances, courts can provide relief from a bargain that is improvident for the weaker party in the contracting relationship. This leads us to the second element of unconscionability, an improvident bargain. A bargain is improvident if it unduly advantages the stronger party or unduly disadvantages the more vulnerable. Improvidence is measured at the time the contract is formed. Unconscionability does not assist parties trying to, quote, escape from a contract when their circumstances are such that the agreement now works as a hardship against them, end quote. Improvidence must be assessed contextually. In essence, the question is whether the potential for undue advantage or disadvantage created by the inequality of bargaining power has been realized. An undue advantage may only be evident when the terms are read in light of the surrounding circumstances at the time of contract formation, such as market price, the commercial setting, or the positions of the parties. For a person who is in desperate circumstances, for example, almost any agreement will be an improvident over the status quo. In these circumstances, the emphasis in assessing improvidence should be on whether the stronger party has been unduly enriched. This could occur where the price of goods or services departs significantly from the usual market price. Where the weaker party did not understand or appreciate the meaning and significance of important contractual terms, the focus is on whether they have been unduly disadvantaged by the terms they did not understand or appreciate. These terms are unfair when, given the context, they flout the reasonable expectation of the weaker party or cause an unfair surprise. This is an objective standard, albeit one that has regard to the context. Because improvidence can take so many forms, this exercise cannot be reduced to an exact science. When judges apply equitable concepts, they are trusted to, quote, mete out situationally and doctrinally appropriate justice, end quote. Fairness, the foundational premise and goal of equity, is inherently contextual, not easily framed by formulae or enhanced by adjectives, and necessarily dependent on the circumstances. Unconscionability, in sum, involves both inequality and improvidence. The nature of the law in the contracting process is part of the context in which the improvidence is assessed. And proof of a manifestly unfair bargain may support an inference that one party was unable to adequately protect their interests. It is a matter of common sense that parties do not often enter a substantially improvident bargain when they have equal bargaining power. Obiter argues, however, that the court should abandon the classic two-part approach to unconscionability and adopt a stringent test consisting of 4 requirements: a grossly unfair and improvident transaction, a victim's lack of independent legal advice or other suitable advice, an overwhelming imbalance in bargaining power caused by the victim's ignorance of business, illiteracy, ignorance of the language of the bargain, blindness, deafness, illness, senility, or similar disability, and the other parties knowingly taking advantage of this vulnerability. This higher threshold requires that the transaction was grossly unfair, that there was no independent advice, that the imbalance in bargaining power was overwhelming, and that there was an intention to take advantage of a vulnerable party. We reject this approach. This 4-part test raises the traditional threshold for unconscionability and unduly narrows the doctrine, making it more formalistic and less equity-focused. Unconscionability has always targeted unfair bargains resulting from unfair bargaining. Elevating these additional factors to rigid requirements distracts from that inquiry. Independent advice is relevant only to the extent that it ameliorates the inequality of bargaining power experienced by the weaker party. It, for example, can assist a weaker party in understanding the terms of a contract, but might not ameliorate a weaker party's desperation or dependence on the stronger party. Even where advice might be of assistance, pro forma or ineffective advice may not improve a party's ability to protect their interests. Unconscionability, moreover, can be established without proof that the stronger party knowingly took advantage of the weaker. Such a requirement is closely associated with theories of unconscionability that focus on wrongdoing by the defendant. But unconscionability can be triggered without wrongdoing. As Professor Wadhams compellingly argues, quote, "The phrases unconscionable conduct, unconscionable behavior, and unconscionable dealing lack clarity, are unhistorical insofar as they imply the need for proof of wrongdoing and have been unduly restrictive," end quote. We agree. One party knowingly or deliberately taking advantage of another's vulnerability may provide strong evidence of an inequality of bargaining power, but it is not essential for a finding of unconscionability. Such a requirement improperly emphasizes the state of mind of the stronger party rather than the protection of the more vulnerable. This court's decisions leave no doubt that unconscionability focuses on the latter purpose. Parties cannot expect courts to enforce improvident bargains formed in situations of inequality of bargaining power. A weaker party, after all, is as disadvantaged by inadvertent exploitation as by deliberate exploitation. A rigid requirement based on the stronger party's state of mind would also erode the modern relevance of the unconscionability doctrine, effectively shielding from its reach improvident contracts of adhesion where the parties did not interact or negotiate. In our view, the requirements of inequality and improvidence, properly applied, strike the proper balance between fairness and commercial certainty. Freedom of contract remains the general rule. It is precisely because the law's ordinary assumptions about the bargaining process do not apply that relief against an improvident bargain is justified. Respecting the doctrine of unconscionability has implications for boilerplate or standard form contracts. As Carl N. Llewellyn, the primary drafter of the Uniform Commercial Code, explained, respecting the doctrine of unconscionability has implications for boilerplate or standard form contracts. We do not mean to suggest that a standard form contract by itself establishes an inequality of bargaining power. Standard form contracts are in many instances both necessary and useful. Sophisticated commercial parties, for example, may be familiar with contracts of adhesion commonly used within an industry. Sufficient explanations or advice may offset uncertainty about the terms of a standard form agreement. Some standard form contracts may clearly and effectively communicate the meaning of clauses with unusual or onerous effects. Our point is simply that unconscionability has a meaningful role to play in examining the conditions behind consent to contracts of adhesion, as it does with any contract. The many ways in which standard form contracts can impair a party's ability to protect their interests in the contracting process and make them more vulnerable are well documented. For example, they are drafted by one party without input from the other, and they may contain provisions that are difficult to read or understand. The potential for such contracts to create an inequality of bargaining power is clear. So too is their potential to enhance the advantage of the stronger party at the expense of the more vulnerable one, particularly through choice of law, forum selection, and arbitration clauses that violate the adhering party's reasonable expectations by depriving them of remedies. This is precisely the kind of situation in which the unconscionability doctrine is meant to apply. This development of the law of unconscionability in connection with standard form contracts is not radical. On the contrary, it is a modern application of the doctrine to situations where, quote, the normative rationale for contract enforcement is stretched beyond the breaking point, end quote. The link between standard form contracts and unconscionability has been suggested in judicial decisions, textbooks, and academic articles for years. Applying the unconscionability doctrine to standard form contracts also encourages those drafting such contracts to make them more accessible to the other party, or to ensure that they are not so lopsided as to be improvident, or both. The virtues of fair dealing were explained by Jean Brocher as follows. Quote, businesses are driven to behave competitively in their framing of market situations, or otherwise they lose to those that do. Only if there are meaningful checks on what might be considered immoral behavior will persons in business have the freedom to act on their moral impulses. An implication of this point is that, absent regulation, business culture will become even more ruthless, so that distinctions between reputable business and fringe marketers gradually wither away, end quote. This brings us to the appeal before us and whether Mr. Heller's arbitration clause with Uber is unconscionable. There was a clear inequality of bargaining power between Uber and Mr. Heller. The arbitration agreement was part of a standard form contract. Mr. Heller was powerless to negotiate any of its terms. His only contractual option was to accept or reject it. There was a significant gulf in sophistication between Mr. Heller, a food delivery man in Toronto, and Uber, a large multinational corporation. The arbitration agreement, moreover, contains no information about the costs of mediation and arbitration in the Netherlands. A person in Mr. Heller's position could not be expected to appreciate the financial and legal implications of agreeing to arbitrate under ICC rules or under Dutch law. Even assuming that Mr. Heller was the rare fellow who would have read through the contract in its entirety before signing it, he would have had no reason to suspect that behind an innocuous reference to mandatory mediation, quote, under the International Chamber of Commerce mediation rules, end quote, that could be followed by arbitration under the rules of arbitration, there lay a $14,500 hurdle to relief. Exacerbating the situation is that these rules were not attached to the contract, and so Mr. Heller would have had to search them out himself. The improvidence of the arbitration clause is also clear. The mediation and arbitration process requires $14,500 in upfront administrative fees. This amount is close to Mr. Heller's annual income and does not include the potential costs of travel accommodation, legal representation, or lost wages. The costs are disproportionate to the size of an arbitration award that could reasonably have been foreseen when the contract was entered into. The arbitration agreement also designates the law of the Netherlands as the governing law and Amsterdam as the place of the arbitration. This gives Mr. Heller and other Uber drivers in Ontario the clear impression that they have little choice but to travel at their own expense to the Netherlands to individually pursue claims against Uber through mandatory mediation and arbitration in Uber's home jurisdiction. Any representations to the arbitrator, including about the location of the hearing, can only be made after the fees are paid. The arbitration clause, in effect, modifies every other substantive right in the contract, such that all rights that Mr. Heller enjoys are subject to the apparent precondition that he travel to Amsterdam, initiate an arbitration by paying the required fees, and receive an arbitral award that establishes a violation of this right. It is only once these preconditions are met that Mr. Heller can get a court order to enforce his substantive rights under the contract. Effectively, the arbitration clause makes the substantive rights given by the contract unenforceable by a driver against Uber. No reasonable person who had understood and appreciated the implications of the arbitration clause would have agreed to it. We add that the unconscionability of the arbitration clause can be considered separately from that of the contract as a whole. As explained in South India Shipping Corporation Limited, an arbitration agreement, quote, constitutes a self-contained contract collateral or ancillary to the main agreement, end quote. Further support comes from the severability clause of the Uber Raiser and the Uber Portier agreements and Section 17.2 of the AA. Respect for arbitration is based on it being a cost-effective and efficient method of resolving disputes. When arbitration is realistically unattainable, it amounts to no dispute resolution mechanism at all. As our colleagues Justice Brown notes, under the arbitration clause, quote, Mr. Heller and only Mr. Heller would experience undue hardship in attempting to advance a claim against Uber, regardless of the claim's legal merit, end quote. The arbitration clause is the only way Mr. Heller can vindicate his rights under the contract, but arbitration is out of reach for him and other drivers in his position. His contractual rights are, as a result, illusory. Based on both the disadvantages faced by Mr. Heller in his ability to protect his bargaining interests and on the unfair terms that resulted, the arbitration clause is unconscionable and therefore invalid. Given the conclusion that the arbitration agreement is invalid because it is unconscionable, there is no need to decide whether it is also invalid because it has the effect of contracting out of the mandatory protections of the ESA. Conclusion: we would dismiss the appeal with costs to Mr. Heller throughout.
Thanks for the listen, friend. I hope you're able to enjoy that case and learn something new from it. Legal Listening is founded by Zach Battiston and Carly Lyons. It is hosted by Zach Battiston, Carly Lyons, and you, our listeners. Executive produced by Zach Battiston, Carly Lyons, and Anthony Radomile. Audio engineering by Anthony Radomile. Graphic design by Julie Lundy. Check her out online at julielundyart.com. And music done by Matt Radomile at radandkel.com. At Legal Listening, we're always open to new ideas, suggestions, and of course, guest readers. Check us out on Twitter at Legal Listening or online at legallistening.com. Legal Listening, where audio obiter is our thing. We'll catch you in the next case. Bye now.